Does Jewish law allow charging interest? Ribbit. Have you ever wondered about the rules surrounding loans in Jewish law? Specifically, does Jewish law allow charging interest, known as ribbit? This topic is quite significant in the context of Jewish views on debt, wealth management, and personal finance. Let's break it down. Jewish law, based on the commandments in the Torah, generally prohibits charging interest on loans between Jews. Ribbit refers to any increase a lender receives from a borrower for delaying repayment. This rule applies not just to money but also to goods and services. For instance, if someone borrows 6 eggs, they cannot return 7. Similarly, if a neighbor paints a house for free, they cannot repay by painting a larger house. The prohibition is strict. Even if both the lender and borrower agree to interest, the transaction remains forbidden. This is different from other financial rules where parties might waive restrictions. The Talmud defines ribbit as any compensation a Jew receives from another Jew for waiting to be repaid. There are 2 main types of ribbit. The first is ribbit ketzutza, which is biblical interest. This means charging more than the original amount loaned, even if the value changes, is not allowed. The second type is avak ribbit, which refers to situations where the amount returned equals the original loan but the value has increased. This is prohibited rabbinically and is treated with a bit more leniency. Jewish law also prohibits any involvement in the interest transaction. This includes lenders, borrowers, guarantors, witnesses, or intermediaries. When it comes to loans involving non-Jews, Jewish law permits charging or paying interest to them. However, caution is necessary to avoid indirect violations of ribbit laws when money borrowed with interest from a non-Jew is lent to a Jew with interest. In modern times, halakhic authorities have created mechanisms like the Heter Iska. This is a legal business arrangement that allows profit sharing instead of interest. This way, Jews can engage in financial transactions without breaking ribbit prohibitions. Some authorities also allow charging interest to corporations, viewing their legal status as different from individuals. From the perspective of Tzedakah and Jewish philanthropy, the prohibition against charging interest encourages lending as an act of kindness. The Torah commands lending to those in need without interest to promote community support and prevent exploitation. This aligns with the values of generosity and social responsibility in Jewish philanthropy and ethical financial planning. In practical terms, Jewish wealth management emphasizes offering interest-free loans to fellow Jews in need as a form of tzedakah. It also encourages using halakhically approved structures like Heter Iska for business financing. Additionally, it advises against financial arrangements that exploit vulnerable individuals through interest. So, in summary, Jewish law does not allow charging interest between Jews in typical loan situations. However, it provides frameworks to facilitate ethical financial interactions that support community welfare and charitable values.